2018 to 2019 law term.
Good morning, everyone. The Honorable Mr. Justice Ivo Archie, Chief Justice of the Republic of Trinidad and Tobago, Senator the Honorable Jennifer Batiste Primus, Minister of Labour and Small Enterprise Development, Ms. Donna Powell Raphael, Chairman of the Equal Opportunity Tribunal, His Honor Mrs. Sunil Sukraj, Chairman of the Environmental Commission, Ms. Natalie Willis, the Permanent Secretary. Your Permanent Secretary is here? No. Ms. Angela Gervais, Chief Personnel Officer, His Honor Mr. Ramchan Lakshmidyal, Vice President of the Industrial Court, His Honor Mr. Lawrence Achong, Chairman of the Essential Services Division, members of the Industrial Court, Mr. Douglas Mendez, Senior Counsel and President of the Law Association of Trinidad and Tobago, members of the Inner Bar, representatives of the ILO, Mr. Kester Nanko, Chairman of the Employers Consultative Association, heads of trade unions, government officials and representatives of government agencies, representatives of employers' organizations, practitioners of industrial relations, specially invited guests, members of the media, ladies and gentlemen, good morning all. Permit me to extend warm greetings to each of and every one of you as you join us today for the opening of the 2018-2019 law term of the Industrial Court. Your ongoing support to the court is invaluable, and it speaks to the importance you ascribe to the court's role and function as an objective arbiter and pillar of this country's industrial relations governance. In 2017, I spoke at length on the impact of our economic challenges and the role I saw for each of the social partners in ensuring our Twin Island Republic weathered the storm. This year, in view of prevailing winds we have been buffeted by in recent times, I thought it imperative that I refocus our time together on the profound significance of tripartism in labor relations and how we can collectively benefit as a country if we put into practice the tripartite approach to which we have committed in principle. Social dialogue, as it is called, is the collaboration and the coming together of business, labor, and government on issues of common interests relating to economics and social policy. Through tripartism, unions and employers lend their voices and expertise in different areas to manage competing demands in labor management relations and find common ground for advancing national development goals. Today, I seek your indulgence and I invite you to ponder for a while on the importance of tripartism and coherence in the following areas: occupational safety and health, disaster risk reduction, labor migration policies, and policies for harassment in the workplace. The common theme in all of these is ensuring the safety, security, and protection of workers in the workplace, as well as enhancing governance structures to strengthen productivity, resilience, and the growth of businesses that are competitive and create jobs. When I speak of coherence, it is in the context of policy dialogue, policy making, and institutional cooperation for implementation in the areas I've mentioned before. I accept that ultimately it is the decision of government whether or not to accept and to implement recommendations from the social partners. However, the importance of the tripartite process, the importance of the coming together of the minds of the three partners cannot be overstated. 2 years ago, in my address at this opening of the law term of the Industrial Court, I spoke about the importance of adopting, promoting, and fostering proper safety and health policies and practices in the workplace. Since then, a number of natural hazards and safety and health issues, regionally and globally, have given us cause to reflect on the importance of tripartism and partnership for dealing with the impact of such incidents on societies and economies. In our backyard, Hurricane Maria and Irma ravaged Dominica, Barbuda, Puerto Rico, and the British Virgin Islands last year. More than 3 weeks ago, on the 21st of August, Trinidad and Tobago experienced a 6.9 magnitude earthquake that was also felt throughout the southern Caribbean. Although this country has escaped relatively unscathed, citizens are still traumatized by that experience. However, I dare say that it has heightened our awareness of the need for cooperation and coherent policies and action in all aspects of disaster risk reduction, which encompasses disaster preparedness, mitigation, and management. Disaster risk reduction applies to all sectors, including the workplace. Whether hazards result from natural events or human action, they can have implications for occupational safety and health, skills to deal with different aspects of risk reduction and management, the continuity of business operation, and the safety of communities. Tripartite cooperation and coherence are therefore critical to addressing hazards in different spheres, given their significance for the country's effort to achieve sustainable development. In my respectful view, the time has come for disaster risk reduction and OSH to be given priority among the agenda items for tripartite discussions as a means of strengthening our response to hazards which may affect various sectors, including the workplace. There are already institutional arrangements to facilitate such tripartite dialogue. Trinidad and Tobago established the National Tripartite Advisory Council, NTAC, in March 2016. The mandate of this council, and I quote, is to give effect to commitments with regards facilitating tripartite engagement, dialogue, and consultation, and to promote consensus building and democratic involvement among key stakeholders on national development issues, unquote. The International Labour Organization, the ILO, of which Trinidad and Tobago is one of its 187 members, viewed the establishment of this council as a major step. The ILO in its Caribbean news made the following observation, quote, "The establishment of the National Tripartite Advisory Council, NTAC, in Trinidad and Tobago in March 2016 brought with it the hope of tripartite dialogue and a willingness by all parties to work towards social justice. Mechanisms such as the NTAC are meant to be a forum in which governments can engage workers and employment representatives to help translate the decent work agenda into national policies and programs. The proper functioning of such a council is meant to ensure that the interests of all parties are heard. Furthermore, it is meant to be a forum which is consistently used to ensure that input and perspectives feed into policy decision," unquote. The NTAC is still in its embryonic stage. So far, it has discussed the issue of productivity and has examined possible amendments to the Industrial Relations Act and the Retrenchment and Severance Benefit Act. These are very important topics of discussion. However, I urge that due consideration be given at the tripartite level for discussions on the existing policies and framework for occupational safety and health and disaster risk reduction. These issues are of relevance to national development, and therefore social dialogue on the topics can only redound to an integrated response. While we are on the topic of collaboration and cooperation, I wish to take the opportunity to highlight the need for greater coherence among government agencies which have labor-related inspection functions. For example, there is the National Insurance Board, which has labor inspection functions relating to social security issues. The OSH Authority has inspection functions pursuant to the provisions of the OSH Act. The Labor Inspectorate Unit of the Ministry of Labor and Small Enterprise Development has inspection functions with regard to specific issues such as child labor, minimum wages, and maternity protection. And then there are also the maritime labor inspectors. What currently happens in Trinidad and Tobago is that a labor inspector of a particular agency may go to a place of employment to see if there is compliance in one specific area, and then an inspector from another government agency will visit the same business enterprise on another day to look for compliance in another area. For example, the National Insurance Board inspector may go into the business premises and conduct inspection, and then someone from the Ministry of Labor, from the Labor Inspectorate Unit, will go to the same premises, sometime subsequently, and conduct an inspection. And then the OSH Authority may go in and conduct another inspection. When these different inspections are done, is there a sharing of information among the labor inspectors? Do the various inspectors meet and discuss issues and exchange ideas on best practices? Employers and workers' representatives will no doubt also benefit from a more coherent approach to these important inspection functions, including those related to the maritime sector. Other key national development issues that the Tripartite Council may wish to take notice of, with a view of tabling them for an inclusive discussion and debate, relate to migrant labor and the government's current thrust towards addressing harassment in the workplace. The issue of migrant labor and migrant workers is a very topical issue that affects us all. Tripartism will be a very useful way to approach this issue in its different dimensions. The reality is that workers may find themselves interfacing with new colleagues from a different country. Business owners may now find that they are faced with a different workforce, and union leaders may find themselves representing a transformed clientele with potentially diverse concerns. We will all bear witness to the effect of globalization writ large. The Caribbean, and indeed Trinidad and Tobago, has always been a region and a country that has welcomed and embraced people of different faiths, cultures, and origins. A practice which is rooted in the historical movement of people from one Caribbean country to another. In this modern era, where people and information travel and move faster than ever before, it is incumbent upon all social partners to be proactive and to work in tandem with each other to address the various and complex challenges and the opportunities that may arise from cross-border labor migration. In this context, it is critical that we do so within the framework of well-crafted policies and creative mechanisms that allow all social partners, business, labor, and government, to contribute and benefit from this phenomenon. With respect to the issue of harassment in the workplace, I applaud the initiative taken by the government to work assiduously towards the completion of long overdue legislation and policies. Much have been said on this topic by me and by others in many other fora. Therefore, today I will not delve into great detail on the issue. It is self-evident that the Me Too movement in the United States has ushered in a much-needed discussion on sexual harassment of women and men, whether in the world of work, in our schools, our places of worship, or our streets. The National Tripartite Council is well positioned to lend its collective voice and expertise to this debate. I urge you, the stakeholders, to seize these opportunities and to build on the current momentum such that we create workplaces and workspaces in all spheres that are safe for everyone. After all, it has been said that the measure of a society and its people is not on how it treats those who can advocate for themselves, but rather how it treats those who are voiceless. You have a privileged forum from which to influence policies and action, thereby bringing about meaningful change. I urge you to use it and to use it wisely. I will now turn to the work of the Industrial Court for the year under review. For the period September 2017 to September 2018, 1,169 new cases were filed at the Industrial Court, 103 cases less than those filed for the previous year, 2016-2017, which recorded 1,272 cases. Additionally, the court disposed of 932 matters, which is 49 cases less than the matters disposed for the same period in 2016-2017. The disposal rate for this year, 2017 to 2018, is 79.7%, which is over 2 percentage points higher than the period of 2016-2017, when the disposal rate was 77%. The 932 cases were disposed in the following manner. 302 judgments were delivered, 330 cases were withdrawn, 277 cases were settled through the conciliation and the bilateral process, and 23 cases were dismissed by the court. Trade disputes remain the largest number of cases filed at the court for the period 2017 to 2018, and they amounted to 781. There were 76 retrenchment and severance benefit cases filed, which is 12 more than the number filed the previous year, and 52 occupational safety and health cases were filed. Under the prevailing economic conditions, it is not unlikely that there will be the temptation for some in certain quarters to call into question the objectivity and fairness of the Industrial Court. May I therefore take the opportunity to reiterate that which I said in the past about the role of the court and recall some official statistics which show how and in whose favor judgments have been made by the court in recent years. It is my sincere hope that the facts would serve to dispel the misconceptions and unfounded statements that tend to be repeated and amplified in this regard. The Industrial Court plays a key role in adjudicating and settling matters that could either create or exacerbate tensions in the country's industrial relations climate. Respect for the rule of law and the maintenance of good industrial relations are essential for an economic environment that is stable, favorable to local and foreign investment, and conducive to social stability. The country's regulatory framework for industrial relations is shaped by the international labor standards to which Trinidad and Tobago subscribes as one of the 187 members of the ILO. Labor standards are not imposed. They are adopted voluntarily and with the consent of social partners. Moreover, Just as we refer to the international best practices when we want to benchmark different aspects of economic performance, so too in the industrial relations field, reference is made to international best practice with respect to industrial relations, taking into account, of course, local circumstances and situations in comparable contexts. Statements claiming that they are biased in the decision of the industrial court, therefore, need to be considered with reference to statistical evidence. As I have noted in the past, of the total number of cases disposed, and that was 2,744, at the court for the period of 2011 to 2015, 27% were from judgments disposed by the adversarial process, and those were 747 matters. Of those 747 matters, 30% were in favor of the employers. With respect to the non-adversarial matters, 15.6%, 427 cases, were disposed by conciliation. 19.6% cases were disposed bilaterally, that is settled between the parties, and 24.9% were withdrawn. In short, 60.1% of the matters which were determined, 60.1% of the matters were determined in a non-adversarial environment during that period. This trend has continued. Indeed, when you examine the number of matters which were withdrawn for the period 2011 to 2015, which is 24.9%, and the numbers of matters withdrawn in 2017 to 2018, which is 35.5%, you will note that they were withdrawn by unions. As I said earlier, the court also dismissed 23 cases in this year which were filed by unions for want of prosecution. In short, those outcomes were in favor of the employers. These are not the outcomes that are widely repeated, although they reflect the reality of the work of the court. Similarly, it must be acknowledged that companies that value their human resources, respect the country's labor laws and policies, and maintain the practice of good industrial relations are unlikely to be involved in matters which are not settled in a manner agreeable to all parties. Let me emphasize that the court has always carried out its duty in a fair and balanced manner. We will never violate the rights of one of the social partners, and we are committed to fulfilling the mission of the court, which is to uphold the principles and practices of good industrial relations as pillars of industrial peace, economics, and social development. We are fully aware of the importance of these conditions for social justice, economic stability, and sustainable development. The court continues to promote the conciliatory approach to resolving dispute. Last week, 12 judges and the assistant registrar of the court received training in conciliation and negotiation. This training was facilitated by Mr. Rene Pritzer of the ILO Decent Work Team and the Office of the Caribbean, and His Honor Mr. Albert Aberdeen of the Industrial Court. The chairman of the Equal Opportunity Tribunal, Ms. Donna Prowell Raphael, and the registrar of that tribunal, Mr. Narendra Lalbihari, also participated in the training. This is the third conciliation training for judges since training began in 2012. I wish to sincerely thank Mr. Pritzer and His Honor Mr. Aberdeen for the excellent job which they did as facilitators of the training. Access to justice in Tobago. I remain resolved in the commitment which I made in 2012 that persons who live in Tobago have proper access to the industrial court. Each year, from 2012 to 2016, judges of the court agreed and gave up 1 week of their vacation to preside upon cases in Tobago. And I think you know that we got permission from the Chief Justice and we used the Supreme Court for those sessions. This resulted in the hearing and the determination of 109 disputes in 47 days. Over the past year, we have been unable to preside in Tobago due to budgetary constraints. As you know, 2 years ago, the Industrial Court acquired the building formerly known as Sandy Hall at Court Street in Scarborough, Tobago, a building which requires restorative work and to be outfitted as a court. I am pleased to announce that on the 6th of September this year, the Industrial Court and NIPDEC formally executed a contract to begin work on the first phase of the restoration project. It is my hope that the entire project will be completed by the end of next year. Meet with the Court Symposium. The court's flagship event, the Meet with the Court Symposium, was held on the 19th of May this year for the 6th year. This year, the discussion focused on the importance of due process in the industrial relations context and best practices as they relate to progressive discipline in the workplace. The fairly new and interesting concept of social media and its effect on the contract of employment was also examined. This symposium provides a platform for dialogue involving all our stakeholders, and it remains an essential space to discuss prevailing labor relations issues in the country. Many thanks to the ILO and their team for the support that they gave for the event, especially Mr. Shingo Mayake. My sincere thanks to Dr. Leighton Jackson, Dean of the Faculty of Law, the University of the West Indies, Mona Campus, and Mr. Jeff Cumberbatch, law lecturer at Cavell University, Barbados, for their continued contribution and support for this event. Challenges. I decided not to list all. The operations of the Industrial Court continue to be stymied by the continued depletion of the number of court reporting staff. This is an issue which I have addressed each year for the past 3 years. Attorneys and industrial relations experts alike write to the court daily requesting notes of evidence and outstanding judgments. I must admit that it is really difficult for me to repeat the same narrative each time a request is made for notes of evidence and outstanding judgments. The reality is, due to the shortage of reporters, notes of evidence are not prepared and given to the judges in a timely manner. As a result, judges cannot deliver their judgments within a short period of time. Additionally, notes of evidence cannot be made available and given to parties promptly on their request. There is nothing further I can say on the issue except that the reduced number of court reporters continue to affect the efficiency of the Industrial Court. Space. We are still unable to provide adequate space for staff at the Port of Spain branch of the Industrial Court. The staff continue to work in spaces which are far from ideal. The 3rd floor of the court is still occupied by another agency which is not the Industrial Court. I again ask the competent authorities to address this problem urgently. At this juncture, my heartfelt thanks to the members of staff, the judges of the Industrial Court, for their hard work, unstinted support, and commitment to duty in these challenging times. In closing, I again urge stakeholders to actively pursue meaningful social dialogue in the areas I have identified today and in other areas of national development. Tripartism is an important framework that can provide a long-term basis for policy dialogue involving the three partners, employers, trade unions, and government. It provides a structured approach which allows the social partners to express their views, which can be taken into account in policy making and drawing up of coherent implementation plans to deal with various issues which affect employers and workers. Disaster risk reduction, occupational safety and health, labor migration, and harassment in the workplace add to the complex challenges affecting the industrial relation climate in Trinidad and Tobago today. These challenges, in my view, can only be properly addressed when the social partners come together and work together. I respectfully submit that social dialogue and the search for solutions be pursued at the National Tripartite Advisory Council, which is supposed to facilitate, and I quote, tripartite engagement, dialogue and consultation, and promote consensus building and the democratic involvement among key stakeholders on national development issues, unquote. Please remember, when you stand alone, you can do very little. When you stand together, you can do so much. May God bless you, and I thank you all for listening.
Just invite everybody to go into the lobby. We have refreshments for everyone.